Samsung Electronics and another.
Morning, Ms. Agron.
Morning. My Lords, I appear for ZTE, the appellant, with my learned friend Mr. Sepchu. Mr. Alexander, King's Counsel, appears for the respondent Samsung together with Mr. Ward. Before we start properly, shall I just address the point on confidentiality, which should be very quick. Of course, we saw Ms. Cogan's email of yesterday. So far as ZTE is concerned, we can confirm that there's nothing in our skeleton that we consider to be confidential, so that's very straightforward. So far as Samsung's skeleton is concerned, the parties are agreed that the quantum of the offers made on either side is confidential, and we ask for that to be preserved. There's also a further point that Samsung make about the identity of some banks that have provided guarantees that we have no objection to. Struggle to see how it's likely to make its way into the judgment, but Samsung have produced this table of the points in their skeleton identifying what's still confidential and what's not. So I'm happy to hand that up. More broadly though, looking beyond the skeletons, there are confidential materials in the bundles for the appeal, and so I do ask for a 3122 order in the normal way in relation to those documents.
So be it.
I'm very grateful. So by way of roadmap, my Lords, I want to do 4 things this morning. First, I'd like to point you to a few key facts that underpin the judgment of first instance.
Yes, I'm sorry, I'm reminded. We'd like to finish this hearing by 4 o'clock. I don't know whether that sounds doable to you both.
Yes, absolutely.
All right, well, that's helpful, thank you.
I'm very grateful for that up front. That's very helpful. So back to the roadmap. 4 things. First, just point you quickly to the key facts that underpin the judgments at first instance and bring you up to date on a few more recent developments. Second, take you to the judgment, of course, Mr. Justice Mellor, to identify the basis for the declarations that were made. Third, then, I'll address the aspects of my client's conduct that are said to amount to bad faith. So that will take in grounds 1 and 2 of our appeal and the 2 respondents' notice points in that stage. And then fourth, explain why we say that the learned judge's approach reflected a breach of comity, which is our ground 4. But before I get into that detail, if I may just stand back and try to say a few words that attempt to get to the heart of what this appeal is really about, my Lords. In a nutshell, of course, the question for the court is whether it's bad faith for ZTE, my client, to offer to be bound by the FRAND determination of another court instead of accepting Samsung's proposal that the parties should bind themselves now to the outcome of the English FRAND trial. And this case is different in 2 critical respects, my Lords, from the earlier cases.
Can I just ask you, when you're saying another court, do you mean another particular court?
I do. I mean the courts of China.
Not any other court.
Not any other court.
Another
no.
particular court.
And of course, that's a critical point, that there is a real parallel alternative FRAND determination pending in China.
Yes, I didn't want to slow you down. I just wanted to get exactly what it was that you thought the issue was.
I'm really grateful. So we say that this case is different in 2 critical respects from the earlier 2 cases in which this court has made interim licence declarations. The first is that there are parallel alternative FRAND proceedings ongoing in another jurisdiction, namely China. In fact, the Chinese FRAND trial is nearly finished, so it seems likely, all things being equal, that there will be a FRAND determination in China before there's a FRAND determination from the English court. It's the first critical difference. And the second is, unlike the earlier cases, my client isn't only prepared to enter into an interim licence, but has actually made its own interim licence offer. The only material difference between that offer and Samsung's offer is that Samsung's offer involves truing up the interim royalty by reference to the English FRAND outcome, whereas we propose truing up by reference to the Chinese FRAND outcome.
I understand why you draw attention to these matters, but these are, as you would assert, they're differences, but they're factual differences. The point of principle about whether it's bad faith to offer to be bound by the decision of another particular court, that doesn't require that there should be another court that's already up and running. It that might have a fact-sensitive component which would influence the decision about good faith or not. But we need to step back, don't we, first, and uncover the question of whether simply to offer terms which include a particular court is in itself objectionable before considering whether the particular facts, how they're to be interpreted. Do you follow the point that I'm rather clumsily trying to make? Namely, at the moment, your first point of difference is that there is another court that is up and running. But my question back to you is, does that necessarily make a difference?
I'd make 2 points about that. The first is that what will be said against me is that we have got an obligation to make a FRAND offer. And we have satisfied that obligation. We say we've made lots of FRAND offers, but we say that we've satisfied that obligation by offering to take what China sets as the FRAND rate. And so it will be said against me that given our obligation to make a specific offer to submit to FRAND terms, the fact that there is a specific alternative FRAND's determination pending is of importance to the legal framework.
I think I'm going back to a stage that's so elementary. I want to understand, unburdened by my Lord's deep knowledge of this, I want to understand whether there's a disagreement between the parties that the mere idea of proposing a condition as part of your FRAND offer, that there should be further resolution in another jurisdiction, a particular court, whether that's considered in some way objectionable in principle, otherwise you just can't do that, it's not part of the FRAND process, or whether it's perfectly part of the FRAND process, but one looks at the facts. Now, is this a question of legal principle, or is it just simply something that you say is an important part of the factual matrix of this particular case? I
think the first point I need to make is that if this case were to go further, we wouldn't accept that there's any obligation to offer an interim licence at all with respect to my Lord's earlier judgments in Panasonic and in Ericsson. But for the purpose of today,
yes,
of course, we're bound by those judgments. Taking today and taking the case law as it is so far, there is a question about whether there could be an interim licence that says the terms of the interim licence shall be trued up by reference to the FRAND terms to be set by one court or another. And then that puts off the question, that defers the question of which court is going to determine those FRAND terms. If I may say so, it's not a question that your lordships need to grapple with today, because both sides have been clear about which set of FRAND terms they offer. And so there are difficulties.
Right, so both sides are saying it's got to be this court or that court. And therefore we can take it for our purposes that the parties that are before us don't cavil with the idea that one of the terms you can insist upon is that it's the court you want.
For the purpose of today, we certainly don't cavil with that. We say that we are absolutely entitled to offer an interim licence by reference to the truing up exercise to be done in our jurisdiction of preference, where that's a genuine preference and there are genuinely proceedings that will result in the determination of FRAND. So it's a court of competent jurisdiction, which is clearly the case here.
Thank you.
And hasn't been the case in the earlier bits of litigation where interim licence declarations have been made. And that's the critical difference that I identify, because in Panasonic and in Ericsson, there was no credible, as the court found in Ericsson, alternative FRAND determination pending to the English FRAND process. So the court's logic in those cases, the ratio of the decisions that we apprehend from my Lord's judgments, was that the bad faith consisted of the fact that the only purpose for which the licensor, the net licensor in those circumstances, could be pursuing interim injunction applications was to try and secure higher rates under the patent licence agreement than would have been secured from the court process, where the English court process was the only credible show in town. So the bad faith consisted in pursuing those interim injunctions where the purpose could only be to secure super FRAND rates. In this case, and I'll show you in the judgment, the judges accepted not without some critical words of my client, but the judge has accepted that my client is pursuing a genuine jurisdictional preference for China, and that makes a critical difference. And I ask your lordships to keep in mind that it's not only ZTE that has a jurisdictional preference in this case. Samsung also has a jurisdictional preference for an English FRAND determination. Looked at through clear eyes, my lord, the interim licence application to which this appeal relates is all part of Samsung's own strategy for promoting its own jurisdictional preference by seeking and, turns out, obtaining declarations that it's in bad faith for my client not to commit to the outcome of the English process. This is one of the means by which Samsung is trying to put pressure on my client to be bound by the English FRAND determination rather than the Chinese determination. So I've got to start by asking your lordships not to approach this appeal in a value-laden way. You'll see that one of our criticisms of the judgment below is that we say the learned judge wrongly proceeded from the premise that the starting point, the default or the assumption was that England was the jurisdiction that was going to determine the FRAND terms, and that any deviation from England as that jurisdiction had to be subject to particular justification, and the learned judge considered that our justifications didn't come up to snuff. But once you realise that both sides actually have preferences as to jurisdiction, then in my submission it becomes clear that actually Samsung and ZTE's position are really mirror images of one another. We've both offered interim licenses. We've both pursued interim injunctions in various countries around the world. The role of the interim injunctions mustn't be exaggerated, as it happens, because thanks to the partial stay that's been agreed in Germany, there actually will be no further interim injunction applications in either direction heard before February next year, by which time the Chinese court may well have determined the FRAND terms. And in fact, if anything, it's Samsung's campaign against ZTE that's gone further, because you've seen that until it was stopped by the German court granting an injunction, Samsung was seeking to have ZTE expelled from ETSI.
Could you encapsulate it in this way? That let's suppose you were considering this the other way around and not looking at the English proceedings first, but looking, say, equally at the Chinese proceedings. Would it be open to you to go to the Chinese court and say that Samsung were acting in bad faith by having started these proceedings? I mean, could you illustrate your point by saying that for every application that could be made of that sort in one jurisdiction, the same application could be made with at least as much credit in the other jurisdiction? Is that your...
That's absolutely, that was in fact the next sentence on my speaking note, my lords, that if there's bad faith on this side of the court, by parity of reasoning, there must also be at least the same quantum of bad faith. We say more because of the ETSI angle on the other side of the court. But we're not trying to foist our interim licence on anyone. We've offered an interim licence, we're happy to sign up to the interim licence, we will bind ourselves to a FRAND determination. But I'm not standing here throwing around allegations of bad faith against Samsung.
So wouldn't the when you've got two interim licenses where the only difference that matters between them is that they both contain a clause that says a particular court is the truing up court.
Yeah.
The right thing to do in these circumstances is to have an interim license which allowed either court to adjust it.
Mm-hmm.
Why does it have to be? Why are you right that it has to be the Chinese court? You're as bad as them on your case.
Mm-hmm. So that was a question that the judge below put to the parties, and in fact it turned out that Samsung were not prepared to enter into or offer an interim license that was genuinely neutral as between the courts. There was a proposal that was produced, but it baked in the English FRAND determination as being the one that was the more important. Of course.
That's not an answer to my question.
No, it's not an answer to your question. But on the other hand, one can only accept an interim license offer that's been made, and it's not.
I'm talking about the one you're on.
Yeah, and one offer might have been to enter into an interim license subject to truing up by reference to the terms of the first court that would decide the FRAND terms, that would set FRAND terms. One apprehends that there'll be then all sorts of arguments about potential for appeal.
Sides. I mean, the point is, you're trying to what you're both trying to do is try and set it up now so that someone forces the answer to which court will finally make the final decision. And isn't the right thing to do at this stage, as a general matter of how you do interim relief in any proceeding, is to hold the ring and not make decisions which finally have those kinds of consequences. So since you both agree that we should be interim license, at least at this level, surely that's the answer to what sort of interim license it should be.
So, and I understand this isn't the way the process is usually meant to work, but just to make sure that I understand what my lord's saying.
Yes. And what I mean is an interim license which does not force the final issue of saying that one final court is better than the other.
Yes. So an interim license that says that there is a license in place for now with payment X, but
Trued up in the end.
and it'll have to be trued up by
It doesn't
reference
say
to.
that there's an exclusive jurisdiction that one court or the other has the right to do that.
I hear what my lord says about that. If I may, that's something that I'll need to take instructions on. But I hear what's said. Would it be all right for me to carry on?
Yes,
and,
of course.
So to go back to the kind of critical path, what's said against me is that it's not our preference for China that's the problem. It's not criticised that we prefer China as a jurisdiction, but what we're doing, what ZTE is doing to promote that preference. So what we need to look at today is what's said to make it bad faith for ZTE to prefer to be bound by the Chinese FRAND determination, but not bad faith for Samsung to prefer to be bound by the English determination, how you break that tie. And you're being asked to consider 4 candidate reasons, and it might be helpful just to identify those up front before I come to them in more detail. The first is the interim injunctions, which I've already mentioned, the fact that ZTE is seeking interim injunctions against Samsung. The second point relied on in the judgment is that the English court was first seized by a matter of 2 working days and during a contractual standstill period. The third point that's relied on in the respondent's notice is the fact that China is ZTE's place of incorporation and headquarters. We say that argument was rightly rejected by the judge. And the fourth point that's relied on, the second point in Samsung's respondent notice, is that ZTE's refusal to commit now to the outcome of English FRAND is at odds with the fact that the English court has jurisdiction over the proceedings and that there's been no forum convenience challenge. So it has and is exercising jurisdiction over the proceedings. And then when we look beyond bad faith, we come to the question of comity. In Panasonic and in Ericsson, so the 2 earlier cases, this court found that the interim license declarations didn't interfere with other courts' jurisdiction to grant injunctions because it was for those other courts to make an assessment of the facts before them and decide whether they wanted to grant, they considered it appropriate to grant an injunction or not. By contrast, we say that the declarations in this case do inevitably involve an interference in another court's jurisdiction because the nature of the exercise in which the Chinese court is engaged is the same as the English FRAND trial. The judge made clear, and I'll show you in the judgment, that the purpose of the declarations was, in the judge's words, to force ZTE to reconsider seeking a Chinese FRAND determination. So, in declaring that it was in bad faith for ZTE not to accept that the English court should set the binding FRAND rate, the English court's inevitably and inherently saying that it considers the Chinese court less well suited for that task than it considers itself to be. And we say that...
Well, I mean, that's you describe an inherent, sort of rather indirect expression of a lack of comity. I mean, how does one treat the fact as to which I direct no criticism, that that since the English court set a FRAND trial date for January, the Chinese court set a FRAND trial date for now. I mean, how does that fit with comity in this world?
Well, there's certainly, if the point that my lord has in mind is the possibility that the Chinese court is engaging in some sort of race to be the first to hear.
No, I'm not. I've nothing in mind. I'm just reflecting the fact that it seems to me that if we're talking about comity, that there's a rather larger beast in the room in comity terms than the one that at the moment you're examining, which is what's to be gleaned from the approach of the English court.
The FRAND trial in
everything in this case seems to have just a mirror element to it. So I mean, when you start with that and you get a room with a number of mirrors, it becomes very hard to see where the walls are.
It's a good metaphor, my lord. It might be helpful to know, to remind you that the English FRAND trial is also expedited.
Yes,
so
but I understand. I'm not. This is you've urged us to be value free. I'm being completely value free in considering this point. I mean, just that it might be said, might be argued. I don't know that the comity works both ways.
Yes, there has been no suggestion, and there's no basis for any suggestion that the Chinese court is engaged in any kind of attempt to race the English court to a trial. And there's been no suggestion of any interference with the English court's jurisdiction by the Chinese court. So although there's a mirror image in so many ways, there's no mirror image to the declarations made by the learned judge, for example, in the Chinese court. There's been no suggestion that the Chinese court is doing something different or unusual as a matter of its procedure. Both courts are just proceeding to hear the FRAND trials, doubtless in the way that they consider most efficient and most effective. And so it hasn't been suggested, and I'd submit that there would be no proper basis to consider that there's any risk of lack of comity or lack of mutual respect from the Chinese court towards the.
Well, I've read the Supreme Court decision, and that was their conclusion also.
Yeah. So, with that by way of introduction, let me get into the meat of the case. It might be helpful just to show you first the way that the critical facts map out. And the easiest way of doing that is probably by reference to our chronology, which is at Core Bundle tab 5. And I'm just going to skim through this quickly, but there are a few facts that just anchor the whole case, and it might be useful to remind ourselves of them. So if you start at page 33 of the bundle, you see this is a ZTE chronology, but it isn't suggested that there's anything in it that's controversial, and Samsung haven't produced their own version, for example. So you see the first entry is July 2021, when Samsung and ZTE entered into the original patent cross-license agreement, and that expired, you see, on the 31st of December 2023. So that's the date of the previous cross-license. And then you have the covenant not to sue period. And you see from the entries for the 1st of January 2024 and the 31st of December that covenant not to sue period spans the calendar year 2024. And right at the end of that period, a day after the parties, a day after the entry on the 18th of December, you see on the 19th of December that these proceedings were filed. So by Samsung, with the usual claim for a FRAND injunction. So the proceedings were commenced during a contractual covenant not to sue period. Now, the proceedings as initially commenced were designed so that they covered 5G only, which was not within the contractual scope of the covenant not to sue. And that claim then acted as a Trojan horse to be later amended after the expiry of the standstill period to cover 2G and 4G, the true intended scope of the licence. And so it's important, this is a feature that didn't appear in the judgment below, it's important to understand the circumstances in which the English court came to be first seized of these proceedings. And then if we continue down, you see on the 20th of December, Samsung filed the Frankfurt proceedings against ZTE. So again, Samsung, the first to claim an injunction, the first to bring proceedings, and also the first to introduce a multiplicity of proceedings across different jurisdictions. And then below that, the 23rd of December, we, ZTE, filed the Chongqing claims, which is the Chinese FRAND determination proceedings, 2 working days later, over the weekend before Christmas, recognising that it was important to get the Chinese court seized because that was the jurisdiction of preference from the outset. So that was a genuine preference from the very outset, and the contrary's never been suggested. And then you see the 1st of January, there are 3 entries for that date. 2 of them are interim injunction applications that were commenced by my clients in Munich and in the UPC. But then on the same day, the same time, we offer the global standstill, the global litigation standstill, where we say, look, let's not have litigation all around the world. Let's just agree on one forum for the parties to do their FRAND determination. We're proposing China. So again, we're the first to make that proposal. You see on the 14th of February that you get a mirror image proposal from Samsung. So about 6 weeks later, they propose that there should be a global litigation standstill, but this time with a preference for England rather than for China. And that was followed by a blizzard of interim injunction applications by Samsung. Over the page, you see in March and in April and May, the parties made their interim licence offers. Again, the first interim licence offer was made by my client. Offers were made on both sides. They converged over time, unsurprisingly, so as to get to the point where now, before your lordships, the only real issue that matters is the question of which court should do the truing up. But again, it was my client that made the first offer there. And that takes us to the hearing before Mr. Justice Mellor, and then to bring the proceedings up to date by reference to what's happened since. If we pick up on the 18th of July, so towards the bottom of page 36, you see the Samsung letter to ETSI requesting the removal of ZTE's patents from the cellular standards. So that is Samsung opening up a new front in the war, saying, let's have ZTE's patents thrown out of the ETSI standard. And that process went on over the following few months. Essentially, ETSI said no to...
What's the relevance of all this? I mean, this is an appeal from a decision which was handed down on the 26th of June. What does it matter to us, apart from knowing generally that the facts? That what do we need all the subsequent events for in deciding whether the judge was right or not?
For a couple of reasons. The first is that it's important that bad faith should be assessed in the light of all of the facts, and none of this is disputed.
We're not a trial court for issues of bad faith.
No, my lord, no. But it is important to see the full picture on both sides as to what both parties have been doing and what the global picture of the litigation is.
In any normal litigation, we stop where the judge stopped. Of course, things happen after that, but we don't make decisions based on it. I'm not being sceptical. I just need to be educated as to why it's any of our business what's happened since the judge's decision.
One of the things that I'll need to show you, for example, later on, is what the German court thinks of the English court's declarations when it comes to comity, and the context in which the German court expressed its views about that are in the context of the ETSI proceedings. So it's important.
But isn't there some sort of structure to this? If the judge had said, well, I think it's very important that the German court thinks this, or would think this, and then you find that the German court has thought that, then there might be some fresh evidence about what the German court thinks. I've read what the German court thinks, but I can't for the moment understand what it's got to do with whether the judge's approach was either correct or not in law, or whether his evaluation was open to him or not.
I say 2 things about
because otherwise, I'm just explaining. Otherwise, what people can do is they can either launch or resist appeals, put in respondents' notices and then engaged in performative behaviour around the world in order to show why they're right.
Yes, I don't think that's suggested in relation to. I don't think that's one of the many accusations levelled against my
No,
client.
but it's one of the reasons why we don't simply range over everything that happens up until the date of an appeal.
I hear what my lord says. I'd just make 2 points if I could. The first is that part of the test of comity is to consider how the exercise of jurisdiction of the English court might be perceived by other courts around the world, which is why in my submission the way that the German court perceives the exercise of jurisdiction by the English court is relevant. And the second point that I make about that is that there are a few respects in which the position has changed since the learned judge gave his judgment below. For example, at the time of the hearing below, we didn't know when the Chinese FRAND trial was going to take place. We didn't know, therefore, when a judgment was likely. And so it may be helpful to your lordships to be updated on those matters. But the chronology's there. I don't think there's any disputes between the parties as to that. And I think I've told you the key points, so I'll move on. So to turn then to the second stage and to look at the judgment of the judge below, if I may, I'm going to start by taking you to the judge's comments on forum conveniens, because they really encapsulate what we say with respect is wrong with the judgment. And that's at Core Bundle, tab 7, page 59. So if you look at paragraph 82 by the second hole punch, forum conveniens issues. So this is the judge cross-referring to an earlier judgment he gave, but renewing an observation. So in my listing judgment, I commented that at times during that hearing, an observer would be forgiven for forming the view that I was being asked to decide which set of FRAND proceedings should be allowed to continue or which FRAND decision should prevail. The same was true at this hearing. Once again, I emphasise that my judgment on this application does not involve such decisions. I'm simply exercising the jurisdiction of this court, which Samsung has invoked and ZTE accepted. Now, in my submission, that wrongly conflates two concepts, which are related but different. Mr. Justice Mellor is absolutely right to be saying there that he wasn't being asked to consider if the English court has jurisdiction. That had been already accepted. It wasn't an issue before him, and the parties were already making progress towards a FRAND trial. So that much is right. But he's, with respect, wrong to say that he wasn't being asked to consider which set of FRAND terms should prevail, because Samsung was asking the judge to make a declaration that it was bad faith for ZTE to refuse to enter into an interim licence binding it to the FRAND terms to be set by the English court. So the judge was quite literally being asked to do, and in fact did, the very thing that he said in that paragraph wasn't in the agenda. And the effect of the judgment is that the declaration is that it is bad faith, it's currently set out, for ZTE not to be accepting that the English terms should prevail. So in this judgment, the judge isn't just exercising the jurisdiction of the English court, as we accept the court's entitled to do and will do. He's going much further than simply saying we're going to be determining FRAND terms in England. He's saying, ZTE, you've got to commit to what we do in England, even though you've got a genuine jurisdictional preference elsewhere.
But isn't he accepting that there might be another FRAND decision in another jurisdiction which might be different?
He is.
Isn't that what he's meaning by saying which FRAND decision should prevail? Not the way you put it, but simply that there may be two FRAND decisions and that's tough.
Yes. So he's saying there that he's not being asked to decide which one should prevail. But if you measure that against the declarations that he made,
Yeah.
which are in the previous tab, Core tab 6, page 40. So paragraph 2 of that order, which is the order made below, says a winning licensor in the position of ZTE would enter into the interim cross-license with Samsung on the terms set out in the confidential annex of the order. And then paragraph 3, the terms, including the sum to be paid of the interim licence, are subject to adjustment and amendment so as to bring the terms into line with the terms of the final cross-license determined to be FRAND by the Patents Court after the FRAND
Yes, that's,
term.
I understand
Oh.
the point. That's a FRAND decision, but it's not saying that's a FRAND decision which is going to prevail against every other FRAND decision that might be made elsewhere. It's just that's this court's FRAND decision.
Yes.
I mean, I'm just not understanding the particular point about conflation, or that the judge was saying which of the FRAND decisions would prevail.
So
He's made his interim decision. He said who's going to true it up later on.
So the test for which FRAND terms prevail in this context are which ones end up in the patent license agreement. That's what matters, because it's the agreement that the parties are going to enter into that will reflect which FRAND
So
terms.
what happens if the Chinese order, when it comes out, says something similar but different?
So
You've then got two decisions,
you've got two decisions.
and the judge is not saying which of those are going to prevail.
Well, the judge is saying that what ought to prevail if we're acting in good faith is whatever the English court decides. So if I may say so, my Lord's observation may have in mind that it's the English court that's going to be deciding whether it defers to the Chinese FRAND decision or not, as if the Chinese FRAND decision is somehow an input into what the English court will decide.
Well, I'm just saying I only understood it to be a recognition by the judge that there may be more than one FRAND decision, and after that, who knows
Yes,
what the consequences of that are.
yes.
That's all I understood him to be saying.
Yes, and what I say about that is that it must, given the declarations made, also wrap in an assumption that it's the English court that's going to decide the answer to that
So a
question.
declaration of the kind made here must be read as saying that this is going to be the only FRAND declaration that counts.
Yes, yes. Or we're in bad faith, and because we haven't signed up to the interim license at the minute, we're in bad faith. That's the current position of the English court, and I say that is not fair, and it's in breach of claimantry.
Just to make sure I've understood it, you say it's paragraph 3 that does that.
Paragraph 3 of the declarations, yeah, or seeks to do so. Yes, yeah.
Right. Would do so if you agreed with it, if you signed up for it.
Yeah, the point that's made against me is that paragraph 4 of the order also matters because it basically gives a pro tem holding the ring position pending this appeal. So it's true that paragraphs 2 and 3 set out the permanent position, but paragraph 4 of the order says you've got to say that you'll sign up, and we haven't done either. But just to complete that picture.
Sorry, just to be absolutely clear, you said the word permanent. You meant, I think, permanent interim.
Yes, permanent interim. That's it. So it's that funny halfway, the funny halfway house between them. Yeah. So that's paragraph 82, and I want to skip then to paragraph 99 of the judgment. So this follows a passage where the judge sets out the injunction applications that have been made on each side, and then analyses those injunction applications. And you'll see paragraph 99 says, in these circumstances, a now familiar and obvious question arises: what's the point of ZTE pursuing the Brazilian, German, UPC and Hangzhou proceedings and attempting to exclude Samsung's products from those commercially important markets with all the massive attendant effort and expense for both parties? So this is the core of the interim injunction logic. Why, ZTE, are you making interim injunction applications? It's really important to read that paragraph in the context of paragraph 102, which looks at the other side of the coin in quite different terms. So 102 at the bottom of page 62 now says, I acknowledge that a similar question can be posed to Samsung as regards the injunctive proceedings they have commenced against ZTE, but the answer is clear. Samsung is seeking to protect its position if its primary aim of an interim licence and orderly progress to the determination of global FRAND terms is thwarted for whatever reason. My lords, exactly the same point could have been made about ZTE. So the word Samsung could be replaced in that paragraph with the word ZTE. And yet the starting position of the court seems to be that ZTE's interim injunction application should be regarded with suspicion, whereas Samsung's should be regarded with benevolence because Samsung's seeking to protect the FRAND determination of the English court. And that's what I say about not approaching this in a value-laden way, as if the default is the English court. And you see the conclusion that the judge reaches in relation to ZTE at paragraphs 104 and 105. So at paragraph 104, so on page 63 now, the judge says one answer is to recognise that a party, here we're talking about ZTE again, may have more than one aim in mind. It's perfectly possible that ZTE had several aims in mind in seeking injunctive relief. A, to put pressure on Samsung to agree to Chongqing as the forum for determination of global FRAND terms, and B, to put pressure on Samsung to agree to supra-FRAND rates. I acknowledge that the offers put forward by ZTE do place the emphasis on the first aim, because the price for Samsung of avoiding injunctive relief was acceptance of Chongqing. For the purpose of analysis, I'll proceed on the basis that the aim was the first. So by the end of this paragraph, you've got to the point where the judge is accepting that both sides are seeking to pursue their jurisdictional preference. And yet in relation to ZTE, that's done with an air of opprobrium and criticism and suggestion that it might be about getting supra-FRAND rates. And there's never, ever, anywhere in this judgment, any suggestion that Samsung might be pursuing a mirror image agenda of its own in having its own jurisdictional preference for England. And you can really see that from paragraph 105, the first sentence. However, that aim gives rise to a slightly different but equally obvious question. Why is ZTE spending so much effort and cost on insisting that the global FRAND terms are determined in Chongqing? And then skipping down 3 lines from the bottom, the answer can only be that ZTE perceive an advantage which must be a substantial one in view of the cost and effort devoted to achieving this aim. Now, the court never asked Samsung why it preferred to have proceedings in England. It never suggested that Samsung must perceive a substantial advantage in having proceedings in England in view of the cost and effort that it was expending, including in this application and now in this appeal. And that's even before the ETSI fandango had begun.
Are the questions at 99 and 105 of the judge's devising?
They are questions of the judge's devising.
And so your essential point is that he could have asked exactly the same questions of both parties.
That's exactly it, and would have come up with mirror image answers, doubtless. There's no difference between the two. And so then we come to the law, to the application of the law to those facts. So if we start at 117, page 67, the judge says he moves to ZTE's argument on jurisdictional preference. So the point that I've summarised to your lordships already. In my view, this argument is based on a misunderstanding of paragraph 153 of Lenovo, my Lord Justice Arnold's judgment, which we will come back to, of course. And what the judge says there is that in that case, just because Ericsson was determined to avoid a FRAND determination by any court doesn't mean that it's good faith for a SEP licensor to use the exclusionary power of national injunctions to enforce its jurisdictional preference. So the judge is really saying, look, Lenovo was a different case about a different thing, and it doesn't establish what you're arguing for here, in this case, ZTE. So we'll come back to that when I take you to that authority. And then the judge goes on to deal with first seized. And the learned judge says at 119, again referring to my Lord Justice Arnold's decision in Lenovo, I don't consider that Lord Justice Arnold was suggesting that first seized necessarily is a trump card in all situations, but it may be a tiebreaker in an appropriate case. And so that shows where the judge considered that first seized, which is another factor relied on against me, is comes into account in the analysis. And I'll come back to that when I make my submissions on first seized. Then I need to show you the conclusion in this section. So the 2 key paragraphs that set out the judge's conclusions are 127 and 130. And it might just be helpful for your lordships just to remind yourselves of those 2 paragraphs. They're really the punchline.
Yes.
So at 127, what the learned judge is saying, particularly in the first sentence, is, look, injunction applications are unnecessary where there are FRAND proceedings ongoing. So a willing licensor would just get on with determining FRAND in the court first seized. So that's the kind of bottom line of the judgment. And then at 1:30, those two factors are repeated. And I just want to say while we're there that a point that's made against me is that the judge applied a multifactorial analysis to determine whether ZTE was acting in bad faith. But if one actually looks at the judgment, you can really see that there are only two factors in the multifactorial analysis. It's the injunctions and the first seize. There's nothing else that's playing into to this analysis of the finding of bad faith. It's worth looking at 134.
Where is the classic statement of what bad faith in this context amounts to? Will you be taking us to that?
Yes. So my lord,
I don't want to. I mean, you're coming to the law at some point, but in most people's world, and I'm not saying this in a partisan way, it applies to both the parties to the appeal. Trying to get as much money as possible for your assets is considered to be good business practice rather than bad faith. So I'm going to need some education at some point as to what it means in this world.
So my lord,
but at a convenient moment.
It's a really fair point, and the holy grail of bad faith in this world are the two judgments of my Lord Justice Arnold in Panasonic and in Ericsson, and they set us out a worked example of something that's considered to be bad faith. I'm not sure that my Lord Justice Arnold has attempted to set out all the circumstances that might amount to bad faith, or a kind of ultimate touchstone.
Let's leave it at this point. I'm just dropping in from the outside the idea that what appears to be regarded as bad faith in this context is not necessarily what a layperson would consider to be bad faith. It doesn't mean that that some concept should not be appropriate in deciding these FRAND issues, because anything that proves in fairness and reasonableness calls for an exercise of judgment. But I'm just wondering whether the actual words bad faith and good faith are the most useful descriptors for what we're actually talking about here, which is whether there's a genuine attempt to seek something that is a reasonable outcome.
That's a really helpful flag before I come to Lenovo, so I'll bear that in mind when I get there. Thank you, my lord. So just before we move on to comity, I should just show you 134, which is on page 70, where the learned judge says, in reaching these conclusions, that's the bad faith conclusion, I emphasise that it's entirely up to the Chongqing court to decide what should happen in the Chongqing proceedings if ZTE wishes to pursue those to trial, which is a choice for ZTE to make. That goes back to the question about which prevails, and then in relation to comity, let me just show you the bottom line of the judgment there, and that's the kind of second plank of this appeal. So the summary position, it's helpful to start on page 73. Paragraph 154, where the judge repeats the point that I've just shown you at 134. So it's for the Chinese courts to decide what they should do with the Chongqing proceedings. I've got no role in that process. And in my submission, the paragraphs that follow show why the reasoning in paragraph 154 is in error. So if you look at 156, in these circumstances, there's no basis in my judgment for criticising Samsung for not accepting ZTE's terms. At best, ZTE's approach results in unnecessary duplication of determination of global FRAND terms between these parties. So it's somehow only ZTE's conduct that results in duplication of global FRAND terms. It may be that relies on the first seized criterion. It's entirely dependent on the first seized criterion, but otherwise, with greatest respect to the learned judge, it just makes no sense because both parties are pursuing separate FRANDs and determinations. And then paragraph 157, as for ZTE, there is a basis for criticising ZTE's conduct in trying through their interim licence terms, backed by their waiver of litigation, to either derail or displace this action. ZTE's terms interfere with the jurisdiction of this court, which they've accepted. in practical terms, ZTE's terms designed to render this action pointless, so that Samsung effectively has to abandon it unless they can bear the prospect of the costs of 2 FRAND determinations. And that is another paragraph where you could replace the word ZTE with the word Samsung and make exactly the same points. So in just the same way that ZTE is criticised there for seeking to pursue its own preferred FRAND determination, exactly the same thing could be said about Samsung, but those points are never made in relation to Samsung. So that's what I say about the judgment. Coming now, if I may, to the grounds of appeal. I'll start with bad faith and then do comity after that, if I may. So on bad faith, the overarching point that's reflected in our first ground of appeal is that we say a licensor isn't acting in bad faith when it offers an interim licence subject to a FRAND determination by a court that can be relied upon to do substantial justice. And we say that China is such a court, and there's certainly no proper basis for impugning China.
Just pause a moment.
My learner friend.
Sorry,
Oh,
just a
sorry.
moment.
Oh, I'm sorry.
No, I was just writing that down. I think this comes back to a point that I was trying to clarify for myself earlier on. A court that can be relied upon to do substantial justice, whether there are proceedings in existence in that court or not. Is that your submit? I realise you don't have to go that far, but it's. Do you say that to make a FRAND offer in relation to a final determination by another court where there are no existing proceedings might have difficulties?
That will certainly be said against me, and let me tell you why.
Why would that be so?
Yeah, so a point that's made by my learned friend in reliance on my Lord Justice Arnold's judgment in Panasonic is that as an implementer, Samsung's entitled to a licence from day one, and we're obliged to offer a licence from day one. And we say, we agree, tick. And the way that we've satisfied that obligation is by offering a licence subject to determination in China. And so I don't
at the moment understand why the fact, why would you not be making a similar indistinguishable offer by saying, and we'll start proceedings in China to make sure that that happens? I mean, why did the Chinese proceedings have to be there already for this to make sense?
Well, it may be that I could still argue that I should win this case if the Chinese proceedings were not yet on foot. But I don't need to go there, and my position must logically be much stronger.
Yes, but the reason why I'm interrogating you about this is because you didn't put this argument, which we wrote down a moment ago, on the basis that we did this and therefore that. You're stating a general principle, which is what we're interested in.
Yes.
Which is that what a licensor has to do.
Yes.
And how it can show it's not acting in bad faith. I was just asking whether an offer to submit to a particular court satisfies your test, as you've stated to us, whether or not the proceedings have been issued.
Yes, I'm looking at it from an advocate's perspective rather than a judge. I see now the point that you're making. Yeah. So all I need to persuade you of in order to I hope win this appeal is that my client is not acting in bad faith if it is committed to a FRAND determination elsewhere, has offered the FRAND determination elsewhere, and that is pending and about to happen. It may be that in another case, a wider argument could be made that just being prepared in the abstract to offer that is enough. But let me tell you the reason why. The difficulty with that on the authorities is that in Ericsson and Lenovo, a case that I also was in for Ericsson, there were parallel FRAND proceedings pending in the US that Ericsson had commenced. In fact, the US court was first seized, and my Lord Justice Arnold and the judge at the jurisdiction challenge wasn't persuaded, in part because of the slow progress of those proceedings.
It wasn't the slow progress, it was the failure to formulate a clear claim for FRAND determination in the US proceedings, when it would have been extremely easy for errors to do that once the lacuna had been pointed out. The judge pointed out the lacuna, and about a year later, nothing had been done.
Yes. It's always so lovely to be reminded of cases that one's lost, but that's absolutely what was said against me in that case. And that what that might be is an example, a kind of worked example of the sort of problems that might arise where a party says, look, we're super happy to have FRAND determined somewhere else. We're going to start a claim in the US, or we're going to start a claim in China. It then might be said to
Yes.
someone in my position, the devil's in the detail.
But that is an important matter in relation to the facts of a particular case, and one can quite see why a FRAND offer elsewhere or an offer to submit elsewhere would have to be credible, effective, etc., etc. But I'm just interested for the moment in the bare principle that you've articulated.
Yes, I'm very grateful, my lord. So to come back to the critical path, what will be said against me is that Samsung have got a right to a license from day one, and we've got an obligation to offer a license from day one. And I say, yes, that's fine, we accept that, and we've discharged that obligation by making the offer subject to FRAND license terms to be set in China. And so you need to look at those four factors to say, well, what transforms our compliance with our FRAND obligation to make an offer into an exercise of bad faith? What means that offer subject to China becomes bad faith? And there are four things that are said against me. I've summarised them just before, and the first is the injunctions. There are three reasons why our injunction applications are not a sign of bad faith. The first is that ZTE has never used injunctions in this case in the way deprecated by this court in Panasonic and in Ericsson. So those cases are not good authority for the result before the judge. I showed you in paragraph 104 of the judgment below that the judge accepted that the purpose of our injunction applications wasn't to apply pressure to obtain a super FRAND rate, but to promote China as our preferred jurisdiction. So what we need to do is measure that against the evil that led to the bad faith finding in Panasonic and in Ericsson. And I hope this will answer my Lord Justice Peter Jackson's point about what the test is, what the touchstone is for bad faith in this context. So let's take it from Lenovo and Ericsson, since that's the last word until now. So authorities bundle, tab 12. And let's pick it up at page 609. So just to orient to orient the panel in relation to which party's which. So Lenovo and Ericsson is Lenovo's application for declarations that it was in bad faith for Ericsson not to enter into an interim licence subject to a pending FRAND determination in the English court. So Lenovo's application. And we can start by taking up what Lord Justice Arnold said in Panasonic as the touchstone. So bottom of page 609, paragraph 127, accepting Lenovo's submission that the core reason for the conclusion reached in Panasonic is equally applicable, and then quoting what my Lord Justice Arnold said in Panasonic. As discussed above, FRAND is a process and not merely an endpoint. Panasonic is not complying with its obligation to negotiate a licence with Xiaomi in good faith and thereby avoid hold-up, but aiming to coerce Xiaomi into accepting terms more favourable to Panasonic than the Patents Court would determine to be FRAND. So that is the kernel of the bad faith that was identified in Panasonic, and that is what the court goes on to apply in Lenovo and Ericsson. That is effectively the legal test that we've got for bad faith, or at least a worked example of the application of that concept in Panasonic and in Ericsson.
Others might, but I don't understand that quotation as being a definition of anything. So I'm explaining why in that case bad faith was found. It's an illustration, as you put it.
It's an illustration.
Definition.
There's never been an attempt in this context to kind of give a comprehensive definition of what bad faith is.
I'm not suggesting there should be. I'm just wanting to know if there's something out there that helps.
This is the yardstick that we've got.
Even might help to look at paragraph 82, which sets out the relevant legal principles, which are French legal principles.
I'm very grateful. Yes, so paragraph 82 of Lenovo and Ericsson, so page 599. And of course, perhaps I should have characterised that, my lord, because the obligations in this field come from ETSI and from the ETSI standardisation regime. French law is the kind of underlay or backdrop to all of these questions. And so I think the point my Lord Justice Lord Justice Arnold has in mind is paragraph 136 at the bottom of page 599, where both parties agree, both parties in Panasonic this was, that in broad terms, good faith requires a party to perform its obligation in such a way that's consistent with the spirit or purpose, not just the black letter. And of course, it's a fact-sensitive question. You see that at paragraph 135, which is just as much the case under English law as well. So to return to paragraph 128 now, which is an application of the ruling in Panasonic to the facts in Ericsson. So page 610 of the authorities bundle. The evil that's identified there is, in the present case, Ericsson is aiming to coerce Lenovo into accepting terms more favourable to Ericsson than the English courts would determine to be FRAND, or at the very least to avoid the risk that the English courts would determine that FRAND terms are less advantageous to Ericsson than those sought by Ericsson. And then there's a cross-reference to paragraph 153, which we will come to. That's an important paragraph. So what the court is, what my lords are saying in saying there is, although for various reasons that probably don't matter for now, Ericsson's conduct wasn't as egregious as Panasonic's conduct, the problem is the same problem. It's that Ericsson was found to have been using interim injunctions to get more money out of Lenovo than it expected that it would get in the English FRAND determination process, which was the only real determination process that was going. And we know that's not the case here. That's absolutely clear, because paragraph 104 of the judge's judgment below says this is about promoting your jurisdictional preference. It's not about extracting a supra-FRAND royalty. So that's the first reason why our injunction applications are not in bad faith, and why Lenovo and why Panasonic are not good authority for that proposition. What's said against me about that is, well, this is just one example of what can be bad faith, and so you can't rely on this case to prove a negative, because it might be that there's bad faith in other circumstances as well. But the second reason why we say that our use of injunctions isn't in bad faith is that we say promoting our jurisdictional preference for China is a legitimate objective for the purpose of which we're entitled to use injunctions. And that submission relies on paragraph 153 of Lenovo and Ericsson, which is at page 615. So again, I'll just give you the factual context because it might be helpful to understand what surrounded this judgment. It's that Ericsson had, as I mentioned before, actually first seized the US court with parallel FRAND determination proceedings. And so Ericsson was relying on those to say, we're using interim injunctions because we want FRAND to be determined somewhere other than in the UK. And that wasn't considered to be credible, and for the reasons that that my lord encapsulated in his intervention. And so the Court of Appeal is essentially just not taking the US parallel proceedings seriously, is the point that matters. And my Lord Justice Arnold says at 153, in the absence of a global dispute mechanism for determining FRAND disputes or an ad hoc agreement to arbitration, the possibility of jurisdictional conflict is inescapable. And I'll skip over the bits about the facts of that case. So 2 lines further below, the principled answer might be that the court first sees should determine what terms are FRAND. In the present case, however, it's plain that Ericsson don't want the EDNC, the US court, to determine FRAND terms for the cross-licence any more than they want the English court to do so. So first sees doesn't work here as a tie-break because the US proceedings aren't credible. And then skip down to about 2/3 of the way down the paragraph. By contrast, Lenovo have offered to accept the EDNC's determination as to FRAND terms if Ericsson dropped their campaign to obtain injunctions and equivalent relief, but Ericsson haven't agreed. On the contrary, they vigorously pursued such relief, in particular in the ITC. And then the critical couple of sentences, this demonstrates that Ericsson's stance is not driven by jurisdictional preference with respect to FRAND determination. It's driven by a preference for the exclusionary power of a national injunction or equivalent relief over FRAND determination by any court. This is hold up. So what is being said there is Ericsson were not genuinely seeking to use injunctions because they preferred to have the case decided.
I understand that. The point is that you draw from that, like you said, that jurisdictional preference is a legitimate objective.
We do, yes. And we go further than that because what's said is, well, Lord Justice Arnold may not have been intending, of course he will know better than anyone, but he may not have been intending to say that jurisdictional preference is an okay basis for seeking injunctions around the world. That's the point that will be made against me. And I say, well, it must be an acceptable basis because if the court expresses scepticism as to whether or not another court should be determining FRAND terms, if it grants declarations that say no, actually it's the English FRAND terms that ought to prevail, that involves a breach of comity because it involves expressing a view that China, on the facts of this case, should be yielding to the UK and that the English FRAND determination should be the one that predominates. And so
jurisdictional imperialism in a word, in 2 words.
That's it. I say that's what must be what must be wrapped in if we weren't right on what we say about jurisdictional preference being a legitimate purpose, my lord. That's absolutely it. And you can test that by considering this interim license application, because obviously the purpose of this application is to put pressure on my client to agree to be bound by an English FRAND determination for fear that if we don't comply, we're going to suffer adverse consequences. And boy, have we seen some attempts at adverse consequences, in particular in the context of ETSI. It cannot fairly be the case that on the one hand, it's in bad faith for us to seek injunctions to seek to promote our jurisdictional preference, but on the other hand, Samsung can do what it likes to promote its own jurisdictional preference, not only with impunity, but actually with praise.
Well, we're not a jury. We've got this point. I suppose you would accept that a jurisdictional preference, if it's to be considered legitimate, must be a genuine jurisdictional preference. So if I say we want the Ruritanian courts to decide this, and they've not done a patent case yet, then that's not likely to be likely to wash.
One can imagine that argument quite so, and of course that couldn't be said about Chongqing. Actually, the point that's made about the Chinese court is much more serious, and I will come to that in a moment. And the third reason, the final reason why our interim injunction applications aren't in bad faith, is that they essentially perform the same role as the FRAND injunction that was sanctioned by the Supreme Court in UP. Naturally, of course, Samsung claim a FRAND injunction in the context of the English proceedings, and our interim injunctions perform much the same function, particularly now that there's been the stay of the hearings in October and in December. It may very well be the case that there's already been a Chinese determination of FRAND by February next year, which is when the next injunction application is due to come on in Germany. And at that point, assuming there is a Chinese FRAND determination, it must be completely legitimate for ZTE to go to a court and say, we're entitled to an injunction unless you sign up to the FRAND terms that have been set by a court of competent jurisdiction and that we're prepared to offer. In other words, it can't be the case that the English court thinks that a FRAND injunction is only okay if it's in support of an English FRAND determination. So that's what I wanted to say about the injunction.
It may not matter for our purposes, and you may not be able to answer the question anyway. But are you able to help us on this? Would the German courts regard a Chinese FRAND determination as a defence to a claim for patent infringement?
I don't know the answer to that question, my lord. I don't know. I can't.
Because part of the problem in this context is that whereas we take the view that it's axiomatic that FRAND obligation is a contractual defence to infringement, for reasons that I find extremely hard to understand, in Germany they view it as having nothing to do with contract. It's purely about competition law, and therefore a FRAND determination gets you nowhere.
Yes, the architecture is different from that which was first described by my lord.
And it's not about jurisdictional preference viewed through the German court's lens either. That's true whether it's English FRAND determination or Chinese FRAND determination.
Yes, that is true.
And the point of the question is, in a sense, it's an insoluble problem viewed from our perspective, but it does invite the question as to what the point is of the forthcoming application, even in February.
Yes, and of course that's a matter for the German courts.
To be sure, absolutely. Yes, I've not intended to imply any criticism of the German courts. It's their approach is different, and there's nobody to say that we're right and they're wrong.
Yes, and that's why my lord, I think you must be right in the first thing you said at the start of that question, which is that it doesn't matter for today's purposes, because really what you're asking, I think, is how do we cut the Gordian knot? And what you said in Nokia and Oppo, for example, which we'll come to in a minute after the break, and in Lenovo and Ericsson, is look, this is just an inescapable feature of the landscape in circumstances where you don't have a supranational dispute resolution procedure, because unless there are rules that regulate the world, then these questions are going to come up. I mean, what you didn't say in either of those cases is that if one court sets itself up as the global arbiter of who's going to decide FRAND, that's another way of cutting through this. But that isn't a solution we urge on you to the problems that we see. I was about to move on to court first seized. I don't know if that's a convenient moment to have the transcribers break.
Is that called for?
Certainly. Well, I think we do have a transcriber, so
We don't normally in this court.
oh, okay. Well, all right. Well, then I'm super happy to press on, if that's all right. Let's do that then. Brilliant. So court first seized. So that's the second claimed ground on which it's suggested that my client's refusal to commit to the English licence is bad faith. And I showed you paragraph 127 of the judgment below, showing that saying that a willing licensor would have got on with determining FRAND in this jurisdiction as the English court was first seized. And we say that there are 4 groups of reasons why it's not in bad faith for ZTE to commit to the outcome of the English court just because the English court is first seized. And the first reason starts from what my Lord Justice Arnold said in the jurisdiction challenge in Nokia and Oppo, which I just mentioned in response to him. So let's have a look at that. That's Authorities Bundle, tab 5, and the relevant extract is on page 258. I'll ask you to remind yourselves of paragraph 16 and 17, but just to give the context in case that's helpful, it's that Nokia, which is a major SEP holder, had brought proceedings against Oppo, which is a Chinese implementer, seeking a FRAND determination in England. Oppo brought parallel FRAND proceedings in China and contested the jurisdiction of the English court, saying that China was the appropriate forum. And so this is the ruling of the Court of Appeal of this court, rejecting that argument, and my Lord Justice Arnold gave the only reasoned judgment. So could you just have a look at paragraphs 16 and 17 to remind yourselves?
Yes.
So the point that we understand your lordship to be making there is the point that I summarised just now in response to your question. So absent a global dispute resolution mechanism, parallel FRAND determinations just are going to be part of the landscape.
But also, the point is made that there is a supranational procedure available, and it's called arbitration. So how about arbitration in this case?
Yes, may I come to arbitration in a moment? I absolutely, I recognise that I need to deal with that, and I've got some things to say about that. But could I just finish on first Cs first? Thank you. And you identify also the difficulties with first Cs as a tie break. So you do that in paragraph 16. You say that court first Cs would incentivise rush to court instead of genuine attempts to negotiate, and that would be inimical to the ETSI process, which of course prioritises negotiation and consensual resolution. And the second and third reasons that you give are closely related to each other, which are that a rush to court will not only involve an attempt to get into your preferred court first, but satellite litigation, where each party attempts to anti-suit and reciprocally anti-suit the other. But the broader point that my Lord's comments in Nokia illuminate is that using court first Cs as a tie-break would strongly incentivise forum shopping. And the facts of this case are a really good example of forum shopping. I showed you that the English court was first seized by dint of these proceedings being commenced during a contractual standstill period. So the Trojan horse point about 5G being brought first and then used as a springboard, to mix my metaphors, to add in 2G to 4G. And giving strength to the court first seized as a deciding factor would really incentivise that sort of gaming of the system. You can easily imagine other scenarios that would be even worse than what's happened in this case. What would happen, for example, if a party seized a court first in breach, in flat, flagrant breach of a contractual standstill period? Would that still count as court first seized? Would you have ticked that box? You can imagine scenarios that are even more extreme. What if, under the courts of some other jurisdiction, it's possible to commence proceedings, so seize that court years in advance of a dispute actually arising at all? So you can say, hang on, I'm going to bring some FRAND proceedings in jurisdiction X in relation to the terms of the next but one FRAND licence, and then that court's first seized. Would that count as court first seized? It's an absolute recipe for parties taking advantage, gaming the system, and for satellite litigation. And we say that the judge fell into error by not recognising these problems identified by my Lord Justice Arnold of using court first seized as a tie-break. A second problem with using court first seized is that, again, as the facts of this case illustrate, it may be a very poor guide to which court is likely to rule first. So on the facts of this case, the English court was first seized by 2 working days and the Chinese court thereafter, but the Chinese courts have been quicker by about 3 months to hear the FRAND trial. Is common grounds that they may well have ruled before the English court, the English FRAND trial, has even begun. So which court?
Well, to be sure, but what's the relevance of that? I mean, why is speed to decision a material consideration as opposed to what court is first seized?
Yes. So the
I
point.
mean, you know, for example, when one looks at Brussels 1, you know, the lis alibi pendens provisions are all about which court is first seized. They're not about which court you think is going to decide first.
Hence the Italian torpedo, with which we were all so familiar for such a long time.
Indeed.
Which in my submission did not produce great outcomes for in terms of efficiency of litigation. Not
But
only
you can't base a jurisdictional system upon a prognostication as to speed of decision.
yes, I'm absolutely not suggesting that there should be any such prognostication. Of course, I'm not alleging that anyone's acting in bad faith, so I'm not seeking any declarations as to what anyone should have done or which proceedings should predominate. So that point is neutral in relation to me. What I'm saying, as far as the submission goes, is court first seized doesn't work if you are going to have a springboard for declarations of bad faith, because if you're looking for a criterion, if you're looking for a tie break, then surely it must be relevant. Which it can't just be a question of which party gets through the door of a court quickest. If you're looking at the resolution of a commercial dispute, so that's as far as my submission goes. The third reason why we say that it can't be bad faith to refuse to commit in advance to be bound by a FRAND determination of the court first seized is that under the structure in UP, as set out by the Supreme Court, the moment when ZTE as an implementer, so on that side of the cross licence, the moment we're required to choose between undertaking to take a FRAND licence or potentially be injuncted or be subject to an injunction application at the least, is once a patent's been found valid and infringed. That hasn't happened yet. The first technical trial, just for your information, is in March next year. So this is not a scenario in which ZTE could be put to its unwired planet style election just yet. And I just show you how, remind you rather of how my Lord Justice Arnold mapped out that position in Optis against Apple. So that's in tab 6 of the authorities bundle at page 297. So tab 6, page 297. And this is the appeal from the judgment on the trial of issues about when a party can be injuncted for refusing to sign up to FRAND terms. It's that bit of Optis and Apple. And the context is that Apple had been found to infringe one of Optis's patents, but the FRAND terms hadn't yet been set by the English court. So Apple was saying, well, you can't make us choose between being injuncted and taking a licence because you haven't set the terms for a FRAND licence, so it's too early. And this is the Court of Appeal rejecting that argument. That's where in the legal framework it sits. And the foundation stone is UPSC, as it often is in this context. So page 297, the quote from paragraph 61 of UPSC, nor do we construe the IPR policy as prohibiting the SEP owner from seeking in appropriate circumstances an injunction from a national court where it establishes that an implementer is infringing its patent. So that's the sine qua non for seeking an injunction. And then if you go on to page 299, paragraph 65, the courts, or my lord is here characterising Apple's argument. So you see first line of paragraph 65, it says by their ground one, Apple contends that, and then the effect of the point is summarised in the final sentence of the paragraph. The implementer is only obliged to take a licence or else be injuncted once both A, a SEP has been found valid and infringed, and B, the FRAND terms of a licence have been determined. So that's what Apple's saying. And you reject that reasoning for the reasons that you summarise on page 300, paragraph 74. So bottom of page 300, you say, Apple argued that the judge's construction would enable the SEP owner to avoid negotiations by commencing proceedings, offering to enter into a court-determined licence, demanding an undertaking from the implementer, and then proceeding to a court determination of FRAND rates. And then you go on, this is the critical paragraph. What this argument ignores is that in order to get to step 4, so that's proceeding to a court determination of FRAND rates, the patentee has to get a judgment from the court that the SEP is valid, essential and infringed.
Except, as I pointed out in a later judgment, where there's an undertaking.
Yes. Of course.
enter into a license on terms to be determined by the court.
Of course, that's absolutely right. And I accept that there are case management issues around this as well. So, for example, in Ericsson and Lenovo, you refused our application for permission to appeal about the order of the trials that should happen in these cases. So you said it's not always the case that the FRAND trial has to happen second, and that's now accepted as a matter of case management. That's the way that we proceed. But the point that I'm making is a kind of more basic legal architecture point. It's that the moment, absent an undertaking, of course, the moment when you have to choose between being injuncted or signing up to the FRAND licence is once there's a patent that's valid and infringed. And what these declarations do is fast forward that, bring it forward to an earlier stage of the proceedings by saying, no, you're in bad faith if you don't commit right up front to take whatever the English court determines, even if you're genuinely pursuing a FRAND determination elsewhere.
So I should know the answer to this, but can you remind me, what is the current position of your clients and of Samsung vis-a-vis undertaking to enter into a license to be on FRAND terms to be determined?
So
I mean, and I'm talking there about final FRAND terms, not an interim license.
yeah, so Samsung have undertaken to enter into the license to be determined by the English court, and that's recorded in a recitals to a number of orders. We obviously haven't undertaken to enter into that license to be set by the English court because that's inherent in this application. But we've offered the contractual commitment to enter into the license to be set in China. I'm really grateful. And so then to go back to court first sees, the fourth reason and the final reason why we say that we can't be criticised for refusing to commit now to an English FRAND determination is that as a net licensor, and it's common ground in this case with a net licensor, my client's entitled to choose which FRAND rate to offer. And we are prepared to offer and have offered that to offer the FRAND rate to be determined by the Chinese court. And we say that principle that the net licensor chooses is established by the Court of Appeal in UP and is being applied in a cross-license scenario in Nokia against Oppo. So I should just show you that judgment. So that's in Authorities tab 7. So this was, again, just to give the context, this was a trial before Mr. Justice Mead of some questions, including whether Oppo was already licensed because it had indicated that it would accept the terms to be set by the Chinese court. So the English court found, Mr. Justice Mead found that Oppo wasn't already licensed. In a nutshell, the reason for that was that Nokia's obligation as the net licensor was to make a FRAND offer, and Nokia was entitled to choose to offer the terms to be set by the English court instead of the Chinese court in that case. So just to show you, the case did involve a cross-license. That's at page 321, paragraph 27. You see the first sentence of paragraph 27. From 2018 to 2021, Oppo was licensed by Nokia and granted Nokia a cross-license for Nokia's infrastructure business. So that shows that, like this case, Mr. Justice Mead was dealing with a cross-license there. And then to go to the reasoning, if we take the On My Planet in the Court of Appeal from this judgment, if you go to page 336 of the Authorities bundle, there's a quote from UP in the Court of Appeal. And we can just pick that up from paragraph 125 of UP in the Court of Appeal, picking up at the end of the first line of the quote from 125. If the SEP owner and prospective licensee cannot agree upon the terms and royalty rates for a FRAND licence, and the question of what is FRAND falls to be decided by a tribunal, then the tribunal will normally declare one set of terms as FRAND, and that will be the set of terms the SEP owner must offer. If, however, the outcome of the proceedings is that two different sets of terms are each found to be FRAND, then in our judgment the SEP owner will satisfy its obligation to ETSI if it offers either one of them. it will in that way be offering an irrevocable licence of its SEPs on FRAND terms. So that's the framework, the legal framework that Mr Justice Mead was applying there, and he applies that to the facts at paragraph 251, page 363. Where the learned judge says, I consider that Nokia's interpretation is more consistent with the existing case law, in particular UPCA 125, so what I've just shown you, and relatedly, the concept that the patentee is entitled to choose between two different sets of terms of both the FRAND. And then he goes on to discuss a point from UP in the Supreme Court. So you see 3 lines below. For example, in UPSC, and then skip to the bottom of the paragraph, the court did not express any disagreement with the Court of Appeal's view that if more than one set of terms was FRAND, the patentee could choose. So that is a cross-licence scenario, just like this one. It is Mr Justice Mead saying, I accept it's not binding on this court, but UP and the Court of Appeal, of course, is, and so is the Supreme Court, saying, well, the licensor, the net licensor, gets to choose which set of FRAND terms to offer. And we choose to offer the FRAND terms to be set by the Chinese court.
Is it a peculiarity in this case that it's not an argument about money? Is it a peculiarity that you actually agreed a figure, but are disagreeing about something else?
Well, we've agreed the figure for the interim licence because we accept that the way in which that figure should be determined is authoritatively set out by my lord in.
I was just wondering whether it's a peculiarity in this case that it's not that you're a part on a sum, and that brings you here. Is this a common state of affairs? That
we are very far apart on the sum for the final licence, my lord.
the final sum?
Yeah.
Yes. Not on the interim sum.
Not on the interim sum, because my lord has set out the principles by reference to which that should be determined.
Well, one way of doing it, I don't think we said that it was the only way of doing it, but that's by the by.
That's really helpful. I'm sure the FRAND world is listening, my lord.
I think it's stated in the judgments, actually. I don't think I'm stating anything new there.
So we say we've got the right to choose, and we choose the Chinese court. So that takes me to the first point in the respondent's notice, and that is that that is this point that ZTE's preference to be bound by Chinese FRAND is in bad faith because China is our place of incorporation and where our headquarters are, and that was rightly rejected by the judge. We say. I'll show you how the point is put by.
Well, you'll have the right to respond, won't you, to respondents' notice points? Do you? I mean, I just want you to keep an eye on the timings and make sure that you have an opportunity to deal with your case.
Yes. Yes. I mean,
do as you want. I mean, just so long as we keep within our timetable.
I'm really grateful. I am getting towards the end,
Right.
and we've had this argument below, so I think it's probably helpful for me to say what we say.
Right.
So let me show you how the point's put by Samsung though. That's in their skeleton. So core tab 16, page 191. And this is comparing England and China. So if you pick the paragraph up on the 5th line, you see that Samsung say, Samsung has not sought to choose a home court or a court that anyone has suggested would reach anything other than a true FRAND outcome and be perceived as doing so. So
I
that
apologise,
raises
it's my fault. I haven't found the paragraph.
Oh,
I've got the page.
191, paragraph 60,
60, thank you.
5th line. So Samsung hasn't sought to choose a court that anyone has suggested would reach anything other than true FRAND outcome and be perceived as doing so. So then, of course, the question immediately arises, well, where does that perception come from? What's the reason why China might be perceived as not reaching a FRAND outcome? And you see that on paragraph 88 on page 198. And if you pick that paragraph, which is no longer claimed to be confidential, up on the 3rd line, you see Samsung say, indeed, given that ZTE is a corporation partly owned by the Chinese state, a reasonable negotiating party would reasonably consider it less appropriate that the forum be Chinese, since that tribunal would be an organ of the state that part owns ZTE, whereas a Chinese arbitrator may be an individual with no direct interest in ZTE other than a shared nationality. So the allegation is that the Chinese court, unlike the arbitrator, has a direct interest in ZTE. You need to look at Samsung's evidence to see what the claimed issue of perception actually is. So if you have a look at their evidence, it's in a supplementary bundle. So the second witness statement of Mr. Uy, which is at tab 26 of the supplementary bundle, and page 270, paragraph 60. Now just pick it up on the fifth line. Towards the end of the fifth line, you see Mr. Uy says, in recent years, major Chinese corporations, particularly Huawei, for example, are now often litigating as SEP holders rather than as implementers, as was historically the case. Thus, insofar as the concern or perception was historically that PRC courts may be to award low rates, which rewarded Chinese implementer companies, so they may now wish to award high rates, which would reward Chinese SEP holders. So the suggestion is that there is a risk of perception that the Chinese court would seek to find an outcome in Chinese proceedings that would favour a Chinese entity because since ZTE is minority owned by the Chinese state, the Chinese court has, in the words of Samsung Skeleton, a direct interest in ZTE. My lord, that is an extraordinary allegation. It's the equivalent of saying that this court has got a direct interest in Channel 4, for example, or a direct interest in RBS at the time when it was majority owned by the UK government, and that this court might try, in a case involving one of those entities, to reach an outcome favourable to them.
I'm not sure that arguments about equivalence necessarily apply. Different states do things in different ways, but I mean, we see what's said here.
There's no evidence before your lordship.
No, your point is about the evidence. It's not a generalised approach to say that one state is automatically like another state. There may be perfectly good reasons why states are different.
Yes. Let me just show you the legal test that's the foundation for what this court has to decide about the Chinese court. So it's in Authorities Bundle Tab 1, and it's Ultimo and Kyrgyz. The facts of this case don't matter at all. They're about whether the courts of Kyrgyzstan could be relied upon to do substantial justice. So if you skip to the test on page 27 of the bundle, paragraph 95. This just sets out, this is the Privy Council just setting out what the test is.
Well, more to the point is Lord Collins.
It's Lord Collins, absolutely. Another important point, definitely. The better view, Lord Collins says, is that depending on the circumstances as a whole, the burden can be satisfied by showing that there's a real risk that justice will not be obtained in the foreign court by reason of incompetence or lack of independence or corruption. Of course, if it can be shown that justice will not be obtained, that will weigh more heavily in the exercise of the discretion. And then 2 paragraphs further down, 97, comity requires that the court be extremely cautious before deciding that there is a risk that justice will not be done in the foreign country by the foreign court, and that is why cogent evidence is required. So that really makes my lord's point about evidence. There is no evidential base for this submission. It's based on pure speculation, and we say that it's an unworthy submission. The judge said in his judgment it shouldn't have been made.
Yes.
It's also a point that runs counter to all of the English law principles of jurisdiction, because of course under the English law jurisdictional rules, the fact that there's a connection between the parties or the dispute and a court is a factor in favour of the English court having and exercising jurisdiction. So if this argument, which is that the Chinese court is less well placed to hear the dispute than the English court because of ZTE's connection to China, if that argument were right, it wouldn't be quite so much a case of all roads lead to Rome as all roads lead to the Rolls building, my lords, because where there's a connection between England and the dispute, then the English courts would have jurisdiction. Where there's a connection between the courts of another country and a dispute, the English courts would also have jurisdiction. It's based on a logical fallacy. And it would actually have a particularly pointed effect on the Chinese courts, because the reality, as my Lords Lord Justice Arnold and Birss know, is that in FRAND litigation, in practice, virtually all of FRAND litigation involves one party, at least on one side or another, that is Chinese, either on the implementer side or on the patent holder side, because Chinese businesses are so important in global tech. And so, in reality, it would have a particularly pointed effect on the Chinese court. The main point that's relied on against me, is that in the arbitration context, and I will come to my Lord Justice Arnold's point on arbitration now in this context, but the main point that's relied on against me is that in that context, it's commonplace, I accept, for there to be an agreement that the arbitrators in the arbitral seat shouldn't be of the same nationality as the parties. But that's quite different. Where parties are selecting arbitrators from an effectively almost infinite pool of candidates, it's perfectly reasonable for them to say, hang on, let's set some ground rules on eligibility in order to protect the fairness of the process. In litigation, by contrast, the fairness of the process is protected by national law of the courts where the litigation takes place. So that's why we have a requirement for cogent evidence of a real risk that courts won't do justice before we'll impugn the courts of another country. It's a completely different setup. And while I'm on arbitration, I just want to address my Lord Justice Arnold's point about why isn't there an arbitration in this case. There's a slight flavour in my learned friend's skeleton argument of criticism of ZTE that the dispute isn't being arbitrated. In context, it's quite an odd point, because the whole premise of this application is that it's in bad faith for us not to have submitted to the jurisdiction of the English courts. So we're being criticised on two fronts, but so be it.
No. But the question would arise from the court in any event, particularly in a case where, as you point out, the key difference between the parties is as to which national court should determine what what terms are FRAND. And if there's a dispute as to which national court should determine, an obvious way to resolve that dispute is by having a supranational procedure, viz. Arbitration.
Yes.
So even if one party or other didn't raise the point, the court would be asking the question anyway.
Yes. So I make 2 points about that. The first is that you can see from the materials, the open materials that are before the court, that ZTE has made proposals for arbitration. I'll just give you one reference, paragraph 80 of Samsung's skeleton on page 20. There's a reference to ZTE having made a proposal for arbitration. And my lord, that proposal was discussed at a meeting the day before Samsung issued these proceedings. So it can't be suggested that ZTE wasn't making proposals for arbitration. And the second is, with regret, as we've indicated in a letter to the court, we have to ask the court to be extremely careful, to read and to listen very carefully to what's said about ZTE's stance on arbitration. So, for example, it hasn't been said that ZTE has refused arbitration. It hasn't been said that we haven't discussed that possibility or that discussions aren't ongoing. And so a word of caution about what is said and what isn't said about arbitration, my lords.
I'm not intending to cast aspersions on either party. Nevertheless, the question remains whether arbitration would not be a viable solution to the problem.
I'm sure the parties hear what my lord says. So that's China. Then the final point that's said to be bad faith is forum conveniens, which is a short point. So this is the idea that our appeal is at odds with the fact that we didn't challenge England as either the jurisdiction or forum conveniens. So the premise is that if England is the forum conveniens for the dispute, it's bad faith for us to refuse to commit to offer a FRAND licence on terms to be settled here. Now, the first point again is the mirror image argument. Exactly the same point could be made against about the Chinese court. It also has jurisdiction and is exercising jurisdiction over a FRAND determination. Samsung did challenge jurisdiction in China, but its challenge was rejected at first instance and on appeal to the Supreme Court. So if it's bad faith for ZTE to refuse to be bound by the outcome of the English proceedings because the English court has jurisdiction, then by parity of reasoning, it must also be bad faith for Samsung to refuse to be bound by the outcome of the Chinese proceedings.
And surely, I mean, isn't it enough for a court to have to decide whether a particular set of actions is in good faith or not? Of course, whether somebody else is acting in bad faith as well might cast light on that, but in the end, it's got to focus on the behaviour of the individual person.
Yes.
So it wouldn't do you any good if you were both acting in bad faith.
No, the point I'm really making is that we're not casting any aspersions. So there's no rocks being thrown from this side of the court to the Samsung side.
Yes. All right.
And so we say that this argument is just based on a non sequitur. The reason it's not right either way is that the fact that a court has jurisdiction to determine FRAND terms and will determine FRAND terms doesn't mean that it's the court whose determination should prevail over all other courts. So that's the basic point, and it's essentially another all roads lead to the roles building point, because if the English court should be the court whose FRAND determination should prevail in all cases where it's got jurisdiction, in particular, my Lord Justice Arnold has set out in a series of cases the very low jurisdictional threshold for cases to FRAND cases to become before the English court, under which.
Sorry, what do you mean by a very low jurisdictional threshold? I don't recognise that description, speaking for myself.
I'm not suggesting that I'm quoting from anything that you said, but that in cases what you've said is that where either party has got a UK SEP and wishes to bring proceedings on that UK SEP for a FRAND licence, then it will be entitled to bring that FRAND dispute before the English court. And actually, in all global disputes between serious players, one or both parties are going to have UK SEPs. That's all I'm saying. So we say the forum convenience point is it's wrong for that reason, and that just leaves me with comity. And I've said most of what I need to say about comity in the context of the other grounds, but at heart the point is a really simple one. On the facts of this case, if it's bad faith for us not to accept that the English court should be the one to set the binding FRAND rate, then the English court must be saying it's better placed to do so than the Chinese court. And I can just anchor that back quickly in terms of the judgment and show you the legal test for comity in this context at the same time, which again comes from the earlier judgments of my Lord Justice Arnold. So in core tab 7, if we pick it up at page 71, that's the legal test that my Lord set out. Page 71, paragraph 141. And this is Mr. Justice Mellor in this case quoting from my Lord in Panasonic. Under the heading comity, it's convenient simply to cite Lord Justice Arnold in Panasonic. Comity in this context means that the courts of this jurisdiction should respect the ability of courts in other countries to decide issues falling within their respective competencies, and should be cautious about granting any relief which might interfere with such courts' exercise of their own jurisdictions, or which might be perceived as an attempt to do so, unless there are proper grounds for grant of an anti-suit injunction. And what you decided in Panasonic and in Ericsson is that there was no breach of comity in those cases because you weren't telling, this court wasn't telling courts of other countries whether or not to grant injunctions. It was a matter for them whether or not to grant interim injunctions, and so there was no interference with the jurisdiction of other national courts in those circumstances. But the breach of comity that we're complaining of in this case is different because it doesn't relate to those injunction applications in other countries. It relates to the effect of the declarations on the Chinese FRAND determination proceedings. And I promised at the start that I would show you where the judge said the declarations might force ZTE to reconsider. So I should make good on that. I showed you paragraph 134 at the beginning, so page 70, previous page of the judgment. And the judge says, it's entirely up to the Chongqing court to decide what should happen in the Chongqing proceedings. And we say, not so if you dig beneath the surface of the judgment, because if you look at paragraph 136, just a couple of paragraphs below, Miss Justice Mellor says, picking up the end of the first line, in my judgment, making the declaration sought by Samsung will serve a useful purpose in forcing ZTE to reconsider their position. Reconsider their position as to what, you might ask, but the answer is clear from 138. However, I must also contemplate the possibility that ZTE will not change their minds and will remain determined to have global FRAND terms decided in Chongqing. So that's the undesirable outcome that the judge is identifying in those.
Well, you jumped over the end of 136, but your essential case is that it wasn't really for the judge to characterise your ways as having error.
That's it. Yes. Yeah. There is no error in our ways. Yeah. Yes. So what he's expressly trying to do is get us to reconsider where we have FRAND determined. What's said against me on this is, well, there's nothing in the declarations that directly tells you you've got to abandon the Chinese proceedings, but we know that isn't the benchmark for comity from paragraph 141, which I showed you, setting out the legal test. There's a potential breach of comity where either there might be an interference with another court's jurisdiction, or there might be a perception of an interference with the court's jurisdiction. And we can see that that was actually the express aim of the judge, was to cause ZTE to change our mind and not press a determination in China. Now, what it will be said against me is, well, if the Chinese court does determine FRAND, the English court can take that into account. And I think that was part of what motivated one of my Lord's comments when I looked at paragraph 82 of the judgment at the beginning of my submissions. And just to be clear, we say two things about that. First, that it doesn't detract from the fact that the purpose of this judgment was to persuade ZTE not to pursue a Chinese FRAND determination. That's clearly.
Right, so what it comes to is your submission is that for one court to try and warn off another one of the parties before it from pursuing proceedings in another court demonstrates a lack of comity. Is that the point?
Yes, that's right, yes. And also a lack of comity to the extent that it suggested, well, the English court should see the Chinese court's judgment as an input, a bit like an Advocate General's opinion might be in the CJEU, and decide how much to take it into account. That still puts the English court in charge and the Chinese court as a kind of local advisory opinion. And when one sees it in that way, submit that the breach of comity is clear. That's all I wanted to say about comity. I haven't addressed our ground 3 orally, which is about the declarations that the court made. That goes to a question of relief. I don't think there's anything I need to say about that. You've got our submissions on writing. So unless there's anything further I can help with.
No.
Just one thing, if I may, Ms. Abrams. Can I take you to paragraph 72 of your skeleton?
Our skeleton, yeah.
Which is on page 177 of the PDF bundle, 169. It's where you summarise the point of round 1. And the reason I want to show it to you is because that's where I got the idea that I put to you at the beginning that seemed to surprise you.
Yes.
Because I now understand that I misread it, or at least read it in one way and you meant it in a different way. I follow that. But what I read there was that the error of law was in holding that the SEP holder's offer of an interim licence subject to adjustment by any court of competent jurisdiction could amount to an offer and back pay.
Yes.
And that's where I was coming from when I asked you that question this morning.
Yes.
I still like to know your answer to it if you wish to give it to me at some point, not now, I understand, but that's where that comes from.
That's really helpful, my Lord. I'm really grateful.
So everyone, thank you. Ms. Sepsu, do you wish to follow in any way?
I do not, my Lord.
Thank you very much. Mr. Alexander.
My lords, I'll adopt a similar course in terms of structure of argument, a few preliminary remarks, then some points in relation to the judgment, and then I'll pick up the grounds of appeal. The starting point for this case in our submission is to recognise, in Lord Justice Arnold's words in another case, that there are elements of dysfunctionality about the global FRAND system. And the jurisdiction of this court is, in our respectful submission, properly exercised so as to somewhat limit those dysfunctionalities, one of which is that pending resolution of final FRAND disputes, there can be a degree of jockeying of position by way of injunctions to force a determination one way or another. That takes place against the background of a system set up by ETSI, which, as has been said in a number of cases and is accepted by ZTE here, that there is an entitlement to a license for an implementer who wishes to produce products, and in particular continue the production of products, pending resolution of terms of a renewed license to do so. This court was faced, Mr. Justice Mellor was faced with a situation in which essentially what is required is a interim period between what is known to be a historical license and what is known will be a future license, either to be determined by a court or arbitration or to be agreed. Once one starts with that orientation and an understanding that essentially the starting point should be an interim, starting point should be a license in our submission. The question then becomes, well, what should the terms of such a license be? And should a one or other party be entitled to go around seeking injunctions to force resolution in one way or another, whether it be by terms that are not FRAND or resolution in a particular tribunal, rather than simply granting a license pending determination of the FRAND terms? My client's position is that they are perfectly content with a standstill provision pending resolution of terms. They're not insisting on any given license, but what they do not want is a situation in which they are facing the significant bevy of injunctive proceedings, which are calculated either to force them at risk of very significant loss and damage in various jurisdictions to accept the financial terms that are proposed by ZTE, or to require resolution in an additional forum, I'll use that term, to one which both parties recognise will set FRAND terms in relatively short order and are in the middle of doing so.
Well, the judge didn't base his decision on the first of those two alternatives. He based it exclusively on the second.
On the second, indeed. And
so therefore we can disregard the first.
I accept that. And my general point, though, is that in our submission, what should not be happening in cases of this kind is for there to be injunctions sought rather than for a license to be conferred pending resolution of FRAND terms. And it doesn't matter whether the injunction is sought for the first purpose or the second purpose. In this case, it
doesn't matter, but why doesn't it matter? So one way to look at the remedy of a declaration as to an interim license is that it is an attempt to provide a partial remedy to the problem of hold-up. That is to say, SEP holders seeking to obtain supra-FRAND rates. But if there is a determination of FRAND rates by a court of competent jurisdiction, then that is not the problem. So to what problem do you say the remedy is addressed in this case?
The problem to which the remedy is addressed in this case is, as the judge held, that there are properly constituted proceedings in this country which are going to determine a FRAND rate expeditiously. Expert evidence and factual evidence has already been exchanged in relation to that, and they are set to be determined in January and February next year. It is in our submission wrong in those circumstances for injunctions to be sought in other territories so as to essentially remove the utility of those proceedings altogether, when this court has held, and there is no real suggestion that that is wrong, that those proceedings should continue and will properly determine FRAND terms, and to replace them essentially with proceedings before or a resolution before a different court, to which, in our respectful submission, Samsung is entitled to take objection. And in those circumstances, to seek to force these proceedings essentially to have no effect and to only grant a license on terms which essentially require there to be no such effect is, in our submission, it's not exactly the same wrong as that which is addressed by requiring a licensee to enter into terms that are plainly not FRAND, but it is a wrong of the same kind, and in our respectful submission is properly addressed in a similar way. A significant feature of my learned friend's presentation has been that there is complete symmetry between the parties. We respectfully say that there isn't symmetry between the parties. It is not us who have been, who have in a sense started the war of injunctions to force a resolution in a given forum. As the judge found, it was ZTE who had commenced proceedings to that end, and you've seen the chronology in relation to those, and our position on those has been one of defending ourselves from those proceedings. We do not wish to have those injunctions levelled against us pending the resolution of FRAND terms, and we do not wish that to happen pending resolution of FRAND terms by any tribunal. And in circumstances where we are, as we submit, entitled to a license now, and we're entitled not
This
to be
question, you put that as if this is a distinct point, and at the moment I'm struggling to understand why it's a distinct point, because resort to injunctive relief can only be improper in this context, bad faith, on one of two bases. The first is because you're trying to extort supra-FRAND rates, but as you've accepted, that is not the situation here. And the second is because you're trying to enforce a jurisdictional preference. So it comes back to the same point, doesn't it? You say that you're entitled to your preferred jurisdiction, and I think the only basis for that, but you'll correct me if I'm wrong, is because it's first seized. And you say it's bad faith for ZTE to seek to enforce their jurisdictional preference.
Well, we respectfully submit that it is bad faith for them to seek to enforce their jurisdictional preference by commencing and pursuing proceedings for injunctions around the world in circumstances where this court is properly seized of this dispute, and they simply should not be pursuing those proceedings for injunctions. They should be treating us as licensed.
The logic is they shouldn't be pursuing a FRAND determination in China at all.
Well, our primary submission is that these proceedings, having been properly constituted and proceeding to trial, those are the ones that should determine what the
Yes.
FRAND terms
But I think
are as between
the
the
same thought
parties.
was going through my mind as my lord's, which is, wouldn't it involve you having to come out and say that starting Chinese proceedings at all was an illustration of bad faith?
It doesn't involve us saying that, and for a number of reasons.
Well, if I can extend it, starting and pursuing
Uh,
the Chinese proceedings, why would that not be an extra large example of their bad faith?
well, first, the learned judge did not hold that that was. in
Well,
fact,
exactly.
bad
That was
faith.
my next question.
and-
So, but if you were right about this, why would that not be an illustration of bad faith, that you got here first? They only had to line up and get a FRAND ruling. Trying to set up an alternative jurisdiction in China is itself, on the logic as I see it of your submission, a bad faith activity.
That doesn't follow for two reasons. First of all, it may be said that the mere act of pursuing parallel FRAND proceedings is not itself an act of bad faith. But there may be a more positive reason here, which is that if, as the English court has held in a number of cases, it may be appropriate to take account of decisions of other jurisdictions in making its own FRAND determination, it can hardly be said that it is then inappropriate for those other proceedings to be pressed to their conclusion, so that the English court can, if it considers it appropriate, take account of them. And so we do not seek to go further than to say that the act of bad faith is the raft of injunctive proceedings which are calculated to ensure that China is the only forum that will be determining what FRAND terms are in this case. That is why there is an asymmetry here. It is not us who are seeking, as it were, to force uniqueness upon the court by the wave of injunctive proceedings. Our position is that these proceedings in the United Kingdom should continue, and it's proper that they should continue. And
Puzzled by that. I'm sorry to interrupt, but I thought your interim license application was predicated upon determination by the English court. It's not agnostic as to who determined. So look at paragraph 3 of the order that the judge made.
yes, it is.
You would resist that being stripped out and it being left open as to which court determines FRAND.
Well, that's not a proposal that has been made by the other side yet. It was one that was raised as a question to my learned friend this morning, namely that there should be a what might be called jurisdictionally neutral interim license. I put that in very summary terms. That's not that's not to describe it completely, but that's not something that that ZTE has at any time proposed, and it would indeed be inconsistent with their overall approach, which is to say that essentially the proceedings in the United Kingdom court should come to an end, and that we should be pressured into accepting the Chinese court lane should.
Question to you as to Ms. Abraham. Is that an outcome that's open to this court?
My lord, I would need, first of all, to consider that.
Yes. Well, you'll have the opportunity.
I don't have an answer immediately, but it's
Yes.
something that I can.
Well, I mean,
consider.
we obviously, I mean, it's always useful before we leave at the end of the day to know what the range of choices that are open to us might be.
Of
And I
course.
would just like to know from you both whether that is, whether you like it or not, an outcome that is open to the court.
Indeed. My initial reaction, and I'll try and refine it, is that this court can, in addressing this appeal, make any declaration that it wishes.
But it can make any declaration that was open to the judge.
that was open to the judge, indeed. And given that what was open to the judge was to settle terms of an interim license in any form that he sought fit. So by way of example, had the financial terms not been agreed prior to that hearing, it would have been open to him to do as Lord Justice Arnold did in the earlier cases, to say, well, this should be the approach to financial terms.
Happily, the parties were agreed as to finances. So I think what you're saying is, and obviously I'm not taking this as your final position because you need time to think about it, but I think at the moment you're disposed to accept that the judge could have, and therefore we could, restrict ourselves to declaring that which is agreed between the parties, namely there should be an interim license and it should be on the financial terms agreed between the parties. End of.
Yes, I don't think I would be in a strong position in trying to limit this court's jurisdiction any more than it would have been possible to limit the court below's jurisdiction as to precisely what terms it ought to include as to, for
At the moment,
example,
we've only taken it to the point, and we've not yet heard from both of you about it, you haven't had time to think about it, as to what is available to us. We obviously, if something is available to us, need to understand from you both what you argue should happen as a result, and we haven't got to that point yet.
Indeed. I was only trying to address my lord's
Yep.
jurisdictional question, as it were, first of all.
Thank you.
And there would need to be matters filled in as to what the parties would contend ought to happen. But just to put a footnote to that, before the judge there was a debate, actually after the substantive judgment, as to exactly how the standstill provisions ought to operate and what ought to happen by way of the order pending an appeal to this court. And there was a difference between the parties as to what ought to happen, and the judge made a declaration based on what he thought was the right approach, in that case based on an approach previously taken in Unwired Planet. So that may reinforce the width of the scope of the powers. But for present purposes, we seek to defend the license that the judge, in fact, settled, even though your lordships may consider that a different license is appropriate, if your lordships consider that a license is appropriate at all. So really, I've made the points, and we put in our skeleton the key passages from Panasonic and Xiaomi, which underpin the whole of this line of jurisprudence, namely that in principle, implementers on both sides here are entitled to licenses enabling them to continue their business uninterrupted. And that should be, in our respectful submission, the starting point of any discussion in this context. And that is, if I may respectfully say so, also an answer to some of the points relating to comity or the issues that are raised on the English court exceeding its jurisdiction, which is that the whole purpose of the ETSI scheme is to ensure that parties are and remain licensed, and that if there is an issue that arises, that they are able, in good faith, to determine them, one hopes, by agreement, but not in such a way that leaves lacunae for implementers in relation to their licensing, particularly, we would respectfully submit, in circumstances where, in various different ways, the parties are actually engaged in the process of determining what should happen for a longer term license. And your lordships have seen the references to the various court proceedings and the alternative dispute resolution mechanisms that the parties have been engaged in. So this is not a situation in which it is in any sense necessary for the courts to say, well, we need to treat an implementer as unlicensed in this period and countenance injunctive proceedings that proceed on the basis that an implementer is unlicensed during that period. This is a situation in which, to the contrary, the approach ought to be, in our submission, one of saying that there should be a license unless there is a good reason to the contrary, rather than starting with the proposition that one needs to show some clear element of bad faith to establish an entitlement to a license for to bridge the gap. So those are our general submissions. May I then come to the judgment and just deal with a number of points that my learned friend has made in relation to those as well. We respectfully submit that the judge was entirely correct in the mode of his analysis and the conclusions that he reached based on the analysis and his approach to the facts. The judge's starting point in our respectful submission was right at paragraphs 93 onwards to ask the fundamental question: what terms for an interim license would be FRAND, and whether ZTE were in breach of their obligation to negotiate with Samsung in good faith. Those are in fact separate questions, but the judge dealt with them in our submission correctly together. He went through the history of the proceedings, and in our respectful submission, he recognized, and in our submission correctly recognized, that there was an asymmetry in the position of the parties. My learned friend has criticized the judge for saying, oh, well, you didn't say the same things about Samsung as were said about ZTE. Well, that is because Samsung had not started this campaign of trying to force resolution into its preferred court in circumstances where there was already a perfectly good court, which was proceeding to a FRAND determination. And in our respectful submission, the right approach, which is the one that the judge took, was to look at the factual position as a whole, which he did in his account of the history.
Well, doesn't that submission rather rest on the foundation that the proceedings in the English court are just simply floated down from heaven as a neutral fact? I mean, the English proceedings existed because you started them.
Yes, and that's a fair.
They didn't just happen, and
No.
and the fact that the English jurisdiction is your preferred choice.
Yes, but we respectfully submit that it is true that it is our preferred choice, and it is in our submission a reasonably preferred choice in this sense, that it is a forum to which no reasonable objection can be taken on the basis that it is neither side's home court. It's not composed of nationals, if one follows the arbitration approach of either side's nationals.
So forum shopping is just fine and dandy, provided that the forum that's shopped isn't the home court. Yes?
My lord, I wouldn't put it in quite those sweeping terms. And the reason that I wouldn't do that here is
Well, you shopped for this forum. You say it was a reasonable forum to shop for, but nevertheless you did.
Yes, and in some senses, anyone who commences proceedings in any forum is shopping.
But the point about it in the FRAND context is that because the FRAND obligation is global, you can litigate in principle more or less anywhere in the world. And so the party that starts the first set of proceedings is inherently choosing, to use a more neutral term, the forum in which to litigate.
Yes, I accept
it's
that.
Inherent.
Indeed. And one might say that that is an inherent consequence of both the fact that one can sue anywhere, provided there's a patent, and the fact that in Unwired Planet, essentially what was said was that it was then appropriate for global terms to be settled, and it has subsequently been said that it was appropriate for global cross-licensing terms to be settled. As my Lord Justice Arnold has recognised, a number of these issues relating to what is pejoratively described as forum shopping are to some extent simply natural consequences of the fact that certain fora provide for resolution of disputes of this kind in a particular way, and other fora
So
do not.
The only way to avoid the problem is to go for a supranational forum.
Yes.
And the only one available is arbitration.
Indeed, we respectfully agree with that, my Lord. And as my Lord has seen, we have made proposals. I'm not going to say anything more, as my learned friend considers it inappropriate to do so. We're content to go down that route.
So we end up at this position that both parties say they're happy to arbitrate. So why don't you?
Well,
I appreciate you can't answer that question because it involves going into confidential matters.
I can't answer that question in detail. It takes two to tango, if I may put it like that, in the context.
Yes,
of
we don't want to draw you into this.
And I really don't think I can properly be drawn, because my learned friend would then be drawn into this as well, and there are confidential matters that we simply cannot go into. But this is only to say. Only to say, as I have said before, that we are happy to arbitrate as a matter of principle, and we are happy to do so even now. The proceedings have developed. Indeed, we put forward a proposal even after the hearing before Mr. Justice Mellor to this effect, in order to try and draw a line through all of these proceedings, including the jurisdictional jockeying, interim license, and so forth. But it hasn't been possible to agree terms in relation to that. But
can I ask you a rather left field question? I'm not expecting a considered answer to this, but how about a declaration as to appropriate arbitral terms? If, as one suspects, the logjam is not over the principle of arbitration, but over a lack of agreement as to the arbitral terms, who the arbitrators should be, seat, procedural rules, etc., why not have a declaration as to suitable arbitral terms?
Well, perhaps I can answer that question in two ways. First, would the court have jurisdiction to do that? Following my Lord Justice Jackson's question in relation to the power to set terms, the answer in our respectful submission is yes, it could make that declaration, just as it could make a declaration to the effect that a given forum should decide on how terms should be adjusted, or any of the other terms. Secondly, as a matter of principle, there is, or at least was, agreement in relation to core terms, as my lords have seen in respect of arbitration, that the arbitrators should not be nationals of either of the parties, that there should be, and as we now know, that there has been agreement in relation to whether there should be an interim payment and the adjustability. So in our respectful submission, given that the court has in some senses said time and again that the way through these sorts of logjams is to go down an arbitral route, that in principle the parties are agreed that that is a sensible thing to do, and that it would, to a degree, resolve some of these uncomfortable issues, there wouldn't be a difficulty in relation to that.
Well,
But
I'd just
I
be
think
interested to know, has this been attempted before? I don't mean in this case, but I might get the sense that any such order, whether made by a trial judge or by this court, would be a new departure.
My lord, I cannot think of a situation where that has happened.
Because obviously you can't, in certain circumstances, you can order people to arbitrate. You can't order people in general to mediate. But I think we'd want to be careful before setting up a whole new system of arbitration through declaration. So I see that the point is out there, but
Yes.
it might be a whole different appeal
So
that needed to decide matters of that sort.
So my lord is quite right that there is no authority, at least none of which I am aware, that has made a declaration as to the appropriateness of arbitration in this context. And it should be said that these matters may be quite context specific.
Well, certainly, I mean, I'm sure the courts all the time say that the party should go away and arbitrate and say it loudly and clearly. But there's a difference between the court expressing a view and the court making a declaration of legal status, or and that's what I had in mind.
Well, that is a very fair point, because the court can make declarations as to
Yes.
This is the license that should be entered into if the parties were acting in good faith, and it should have these terms. That is what the court has done.
Yeah, well, it's
in
my fault
earlier cases.
for raising a red herring. I just thought
It's
I
a
would.
very interesting red herring.
But it is a red herring.
My lord, it's probably not profitable to pursue that line now, particularly since neither side really is able to give a definitive position in relation to that.
No,
But,
I mean, there is one matter which is a new point raised during the course of the appeal, which you are going to give further consideration to, which is, as you very, very nicely put it, the jurisdictionally neutral interim license.
yes, it's a matter which my Lord Justice Birss has invited observations should they
become relevant.
should they become relevant, and should ZTE wish to make observations in relation to that. I think probably I'd better wait until the short adjournment before knowing whether we have instructions to
see what the time is, and
put matters
we've
before my
been
lord.
unkind to the transcriber. Would you decide at what point we were 5-1 now, so you can either take a pause now or go forward to 1 o'clock, as seems best to you?
It probably makes sense to. Well, perhaps I could just finish before 1
Yes, absolutely.
on the general points on the judge's judgment, if
Thank
that's
you.
convenient, and then come back and pick up some of the more specific points at 2 o'clock. So we were really in the judge's judgment, and I was seeking to persuade my lord that the judge took account of the correct points in the history that he recounted between paragraphs 93 and 99, and then in our respectful submission asked himself the right question in this context, namely what is the point of these proceedings, and concluded, essentially it was then common ground, that the point of the proceedings was to prefer Chongqing, or to force Chongqing as the forum. It's not just a question of, in a sense, innocent preference of Chongqing. What this was a campaign directed at Samsung to say, unless you agree to Chongqing, we will exclude you from selling your products in very important markets. And in the previous expedition judgment, the judge had articulated the serious damage that those injunctions would do. So this was not just a light touch on the part of ZTE. This was actually, if I may put it colloquially, arm twisting to its home forum. And the judge summarises that, and my lords have seen that in paragraph 104. And the judge then asks the question, well, really, was this a legitimate basis for insisting that those terms were determined in Chongqing, and he goes through the evidential base and the thin evidential base for saying that there was a justification for those terms being determined in Chongqing, and he analyzes in some detail the arguments put forward to justify that, and the relative paucity of the justification in the witness evidence for that preference to be a justifiable one. And he reaches his conclusion in relation to that in paragraph 109, where he says if those were the real answer, he would expect them to have been set out. And he says that while the reasons would support a preference for Chongqing given a free choice, he found them insubstantial in the present circumstances. They might matter if ZTE was an SME, but they don't, and they don't provide a sufficient justification for the way.
Who bears the burden in this situation? Is it for them to show that they're acting in good faith, or is it for you to show that they're acting in bad faith?
Well, our starting point in our submission is that if you accept my submission, that there should be a license that, in a sense, is the interim gap license, and the question then is, should the terms include as a requirement that the matter be heard and determined in Chongqing? Then the question should then, as someone putting forward those terms as a condition of the license, should have to justify that those are terms that are put forward in good faith, and that there's a very good reason for those proceedings to be determined in
I need
Chongqing.
to check over the short agenda, but my recollection is that in both Panasonic and Lenovo, the court proceeded on the basis that it was for the party asserting bad faith to establish it. It wasn't for the party asserting good faith to establish it.
Indeed, but if one thinks about the structure of the argument of being starting point should be a license, and then the question should be one of what the terms
But I
should
think
be.
where it bites here is in relation to, for example, paragraph 108 and the four points. And the judge's his first point was that he was expected to see those in the evidence if they were genuine points. I suppose it rather depends upon who the burden's on to deal with it. But anyhow, is that a convenient moment?
That is a convenient moment. I can come back and pick up the specific points.
Thank you very much.
All rise if able.